Good morning, everyone. Thank you so much for joining us this morning for our July edition of Breakfast Bites. Geraint, can you wave at me to see if just to check that you can hear me properly? Excellent, thank you. I'm Julian Allsop. I'm head of the employment discrimination team. As you probably gathered from the sound check just now, that's my colleague Geraint Probert will also be presenting to you this morning. A few bits of housekeeping, if I may. Firstly, I'm not sure if you can see the slides or not. Geraint and I are having a bit of local difficulty with that, but if you can, you'll probably see what I'm about to tell you. But if you can't, well, I'll tell you anyway. Firstly, please can you mute your microphones? Secondly, if you can, please switch off your camera. And third, I've tried to disable the local control of the PowerPoint slides. But if you do have the ability, unbeknownst to me, to do so, please avoid the temptation to flick through the slides if you can see them. As Geraint pointed out at the start this morning, please can you pose any questions via the chat function, which you'll find in the toolbar at the middle bottom area of the screen. And Geraint and I will answer your questions at the end. This presentation is being recorded, as you might be able to tell, so you'll be able to re-watch it when it's uploaded to our Chamber's website. Now, as advertised, Geraint and I are going to look at the recent key discrimination cases that have been reported since lockdown started. As it happens, they're mainly in the field of disability discrimination, but there's a rare marriage discrimination case at the end, which Geraint will cover for you. So in terms of the cases we're going to cover this morning, we're going to cover firstly Robinson versus DWP, then DWP versus Boyers, then Ishala versus the Transport for London, Hill versus Lloyds Bank PLC, Williams versus Alderman Davies Church and Wales Primary School, then Rakova and London Northwest Healthcare NHS Trust, Morton and Eastleigh CAB, and then finally Gould versus St John's Downshire Hill, which is the EAT case. So I'll kick things off with Robinson and DWP, which was reported as a judgment was handed down by the Court of Appeal last week in relation to the correct approach to be taken to the interpretation of Section 15 of the Equality Act, and also the question of remission in disability discrimination cases. It seems like an age since I last did a Breakfast Bites, but I think that it was just over a year ago, because I drew those who were there at Harvey Nicks breakfast on that occasion to the Court of Appeal judgment that had recently been handed down in the case of Dunn versus Secretary of State for Justice, which you'll find reported in 2019 IRLRs at page 298. And that's significant because it's a case which is similar to the case of Robinson and DWP, and which contained something of a foreshadowing of the judgment in Robinson and DWP. In that case, Lord Justice Underhill gave valuable observations as to the similarities between the test for causation in Section 13 direct discrimination claims, which requires the claimant to have been treated less favorably because of the protected characteristic, and Section 15, which requires the claimant to have been treated unfavorably by his employer because of something arising from the protected characteristic. Lord Justice Underhill expressed the overture view the term because of, which is common to both species of discrimination, requires the same analysis of the thought processes of the individual concerned with the meting out of the treatment that was complained of. And the issue arose directly for determination in the appeal in Robinson versus DWP. Briefly, the background facts are as follows. Mrs. Robinson had been employed by the DWP as an administrator. She suffered from blurred vision in her left eye, which substantially affected her ability to undertake day-to-day activities and made it impossible for her to work on a computer using the specific debt management software known as Debt Manager. The DWP changed its computer hardware, which reduced the screen resolution on the computers, and it adversely affected Mrs. Robinson's ability to see the monitor clearly. Unfortunately, significant technical difficulties were encountered when attempts were made to adapt the screen modification software that was used, which is called the Zoom Text, for use with Debt Manager, as well as the new computer which the DWP attempted to build for Mrs. Robinson, which unfortunately did not succeed in being effective. Even more unfortunately, when they did manage to get Zoom Text and Debt Manager to work together to any extent, and Mrs. Robinson could not see all she needed to because of the magnification, which then caused migraines. This led to a pattern of absence from work on account of stress, anxiety, and depression, and ultimately Mrs. Robinson left the DWP on early retirement. The tribunal held that the DWP had complied with its duty to make reasonable adjustments. The available technical solutions would not have ameliorated the substantial disadvantage that she faced. However, it also found that Mrs. Robinson had been treated unfavorably by the delays in resolving her grievances about the same adjustments and delay in finding and failing to find a solution to the technical issues posed by Mrs. Robinson's disability. And so off the back of that, it extended time for presenting the claim and found against the DWP. DWP appealed to the Employment Appeal Tribunal, and the main ground being, as one might expect, the tribunal was wrong to find the Section 15 claim in favour of Mrs. Robinson because it failed to properly consider the cause of the unfavourable treatment and failed to make sufficient findings of fact to justify shifting the burden of proof under Section 136 of the Equality Act. And Mrs. Robinson cross-appealed against the rejection of the reasonable adjustments claim. Mr. Justice Kerr upheld the appeal and dismissed the cross-appeal. He agreed with the DWP's submissions that the tribunal had in effect applied the forbidden, as he called it, but-for test to the causation under the Section 15 claim. Mr. Justice Kerr found that the finding of the ET was merely an attempt to deal with the consequence of the disability by attempting to find a technical solution that did not succeed. To the extent that it was unfavourable, if at all, that was because the attempt to solve the problem took a long time, it did not succeed, and Mrs. Robinson suffered stress as a result. That was not something arising from her disability as such. Further, whilst the delays in the grievance process were found by the tribunal and not disturbed on appeal as being bureaucratic and reprehensible, Mrs. Robinson's best case, as found by the tribunal, was that she would not have fallen victim to that conduct but for her disability and its consequences. That is not enough, as Justice Kerr said. Mishandling of a grievance is not discriminatory simply because the grievance concerned discrimination. Ms. Justice Kerr also found that the defence of justification must succeed, because to find otherwise in this case present an inconsistency with the tribunal's acceptance of the reasonable adjustments case, which covered the same ground. So the EAT found that the findings of the tribunal really dictated one outcome, which is the dismissal of the discrimination claim. And so he substituted that finding rather than remitting that matter back to the tribunal, as one might otherwise have expected. Mrs. Robinson appealed against Mr. Justice Kerr's judgment on the basis he had erred in substituting a finding, there was no discrimination arising from disability, without properly applying the correct test for remittal, and that his finding was not based on the facts found by the original tribunal. The Court of Appeal, Lord Justice Bean delivering a lead judgment, dismissed the appeal. At the core of its judgment was the acceptance of Lord Justice Underhill's obiter comments in Dunn, which I referred to at the start. Both Section 13 and Section 15 require the tribunal to ascertain whether the treatment was because of the protected characteristic and thus analyze the thought processes of the decision makers concerned. And so a prima facie case is not established solely by the claimant showing that she would not be in the situation of being the victim of delay and incompetence if she was not disabled. As such, the various allegations made by Mrs. Robinson, such as being removed from the DEP department to one where she could work with paper rather than computers, the failure to deal with her grievances fully in a timely manner, the failure to make other reasonable adjustments, and failing to protect her from stress causing a detrimental effect on her health, could not be upheld, as not only were there no findings where the tribunal could have concluded that DWP managers were motivated in any way by a disability or the symptoms of it, so as to meet the initial burden of proof. But even if they were, the DWP's justification case was sound, given the findings in its favour in relation to reasonable adjustments, insofar as the allegations related to the delay in implementing them. The decision not to remit was also sound, because it was in line with established authority. We all know Jaffrey and Lincoln College, but also Henderson and General Municipal and Boilermakers Union, which are to the effect that if the findings of the tribunal could not establish a prima facie case from which discrimination could be inferred, the Employment Appeal Tribunal could properly substitute its own finding rather than remit. So the takeaways from this case are effectively on the slide, but in nearly all cases, in determining whether the treatment complained of was discrimination, Section 15 requires the same analysis of the decision maker's thought processes as Section 13. A prima facie case is not established solely by the claimant showing that she would not be in the situation of being the victim of delay and incompetence if she was not disabled. A finding that the employer has complied with its duty to make reasonable adjustments means that it is likely that a justification defense that relates to the delay in the process of implementing the same issues will also succeed. And finally, the appellate court does not have to remit if the findings of fact do not cross the threshold of the prima facie case. So that's my first case. My second case is also on Section 15. And again, the DWP is involved, and it's the DWP versus Boyers. And this is one in which, again, the DWP is appealing against a finding of unlawful discrimination contrary to Section 15 of the Equality Act. In this case, Ms. Boyers was also employed by the DWP as an administrative officer, and for the periods of time material to this claim, Ms. Boyers suffered from migraines which are considered by occupational health to meet the definition of disability under the Equality Act. Unfortunately, Ms. Boyers had issues with a colleague who she considered had been bullying and harassing her. This led to increased stress, which in turn led to depression, stress, and panic attacks. Ultimately, this led to a deterioration in her mental health that resulted in a period of long-term sickness, which ended with her dismissal in January 2018, save for a short period of time where she undertook a work trial at another location. So Ms. Boyers brought a claim of unfair dismissal and disability discrimination. The tribunal found that she'd been unfairly dismissed, and whilst it accepted the true reasonable's capability, it had issues with the adherence of the DWP to its own procedure, and the extent, particularly in respect to the extent to which consultation took place in the 3 months leading up to her dismissal. The unfair dismissal finding did not find its way to a full hearing before the appellate court. It also considered that the DWP had not taken reasonable steps to conform itself to the true medical position before dismissing her. Again, a finding that did not find its way into an appeal. The ET also was of the view that the decision maker had unreasonably concluded that Ms. Boyers was deliberately not complying with the attendance management procedures and was being obstructive. She also failed to follow advice given to her by HR by failing to check on the reasonableness of the work trial arrangements and if alternative roles and adjustments had been offered to Ms. Boyers at the end of the trial to assist her back to work. So the tribunal was critical of the decision maker in relation to the way in which they approached the evidence given by the decision maker. And also they were critical of the fact that she'd not give any serious thought to alternatives other than dismissal, but went ahead in a preordained way to dismiss Ms. Boyers. Off the back of that, the tribunal also upheld Ms. Boyers' Section 15 claim. It was not in dispute that Ms. Boyers was disabled, nor was it in dispute the dismissal was unfavourable treatment arising from her disability. Sole issue was justification. The tribunal, though, however, found that Ms. Boyers' dismissal was not a proportionate means of achieving a legitimate aim. Legitimate aims in the case were twofold, the first of which was identified as protecting scarce public funds and resources, and secondly, reducing the strain on other employees of the DWP caused by Ms. Boyers' absence. Two fairly common legitimate aims. In rejecting the proportionality decision to dismiss, it focused on the same matters that had been relied upon in relation to the non-adherence to policy and the failures in the decision-making process that had been relied upon in deciding that Ms. Boyers had been unfairly dismissed. So it merged the two thought processes. It summed it up by stating that it assessed all the above factors and said, we conclude that in dismissing the claimant in January 2018, the respondent did not act proportionally to the aims it was seeking to achieve. There was more that could proportionally and reasonably have been done to assist the claimant back to work, particularly by building on the positive aspects of the work trial, rather than concentrating on the negative aspects of that trial. Whether or not any further action would have yielded results is a very different question, as one for consideration at the remedy stage of this claim and not the liability stage. So the DWP appealed against the finding that it hadn't acted proportionally. The main ground that the tribunal had focused impermissibly on the failures in the decision-making process and the procedures that DWP adopted in deciding to dismiss Ms. Boyers rather than considering other factors. And the EAT agreed that this had occurred. And in determining that the judgment held effectively that when considering whether a discriminatory measure is objectively justified, the tribunal must balance the needs of the employer, as represented by the legitimate aims being pursued, against the discriminatory effect of the measure on the individual concerned. This involves considering the way in which the legitimate aims being pursued represent the needs of the business, the focus being on the needs, and a balancing of those needs against the discriminatory effect of the measure concerned. So, having identified legitimate aims and the protection of scarce public funds, the protection of scarce public funds and resources, and reducing the strain on other employees caused by Ms. Boyer's absence, the tribunal fell into error because it failed to analyze the evidence regarding those matters and to assess objectively those needs against the seriousness of the impact of the dismissal on Ms. Boyer. It was fatal to its decision-making that the tribunal made no such findings on the DWP's evidence in relation to proportionality at all, and that fell into error because it determined the issue of proportionality rather than on those matters of assessing the balancing off of the needs, on the actions and thought processes of the DWP's managers rather than on balancing those particular needs. And those needs being balanced, of course, in the context of legitimate aims it had found were pursued by the dismissal and the discriminatory impact on Ms. Boyers. So therein lies the problem, and on that basis the appeal was upheld. There was a challenge, and those of you who will recall O'Brien versus Bolton and St. Catherine's Academy, that case involving Section 15 unfair dismissal, and in particular the question of whether or not you will tend to have consistent judgments both on justification and range of reasonable responses in respect of a dismissal. We'll recall that case, and that was considered in this judgment, but it was distinguished on the basis that, unlike in the O'Brien case, in this case it was the Section 15 finding that was an issue rather than the unfair dismissal finding. And the fact that dismissal was found to be unfair on procedural grounds without properly analysing the justification defence permitted the possibility of there being a different result on the Section 15 and unfair dismissal claims based on the same dismissal. So the takeaways from this case are, effectively, one, in considering justification, it's not permissible for the tribunal to focus on the failures of the procedure and decision-making that led to the discrimination. Two, the tribunal should have analysed the evidence relating to the legitimate aims and balanced off the needs of the DWP in the context of legitimate aims against the seriousness of the impact of the dismissal on Ms. Boyers. That leads on to my third case this morning, which is the case of Ishala and Transport for London, reported this year, 2020, IRLRs 368. In this case, Mr. Ishala was employed by Transport for London for 8 years. At all material times, he was a disabled person suffering with depression and migraines. After a period of long-term sickness, he did not return to work and was dismissed on the grounds of medical capability. And he brought claims before the, employment tribunal, which for the most part we do not need to concern ourselves with. Suffice to say, he was successful in establishing there was a breach of the duty to make reasonable adjustments on a limited basis. However, he did not succeed in establishing that there was a PCP of requiring the claimant to return to work without conducting a proper and fair investigation into his grievances, which he said were not properly and fairly investigated prior to his dismissal. The tribunal found there is no such PCP operated by Transport for London because the alleged requirement was a one-off act in the course of dealings with one individual. Mr. Ishala appealed on the basis that an ongoing requirement or expectation that a person should behave in a certain manner, here, return to work despite the outstanding grievances, is a practice within the meaning of Section 20, subsection 3 of the Equality Act. And his submissions were based upon the case of British Airways PLC versus Starmer, this is a well-known Court of Appeal case, where a PCP was found in respect to a decision by British Airways to refuse a request for part-time working on a 50% basis by an individual pilot, in this case Ms. Starmer, despite the introduction of a wider policy to make part-time opportunities available to accommodate employees' requirements for childcare and the like. In that case, the Employment Appeal Tribunal held that the employer's decision amounted to the application of a PCP that Ms. Starmer had to work full-time or 75% of the time. Mr. Ishala also challenged the correctness of Nottingham City Transport Limited versus Harvey, a case that Geraint will touch on later on, where a one-off flawed application of a disciplinary procedure was held not to be a practice. So in essence, Mr. Ishala's submission amounts to an assertion that all one-off acts and decisions qualified as PCPs, given the wideness of the jurisdiction under Section 20. Lady Justice Simler rejected Mr. Ishala's submissions. She held, in a very useful judgment on what constitutes a PCP, particularly a practice, that all the words, the three words, provision, criteria, and practice, each of these are ordinary English words. They are broad and overlapping, and they're not to be narrowly construed. They have significance because Parliament chose them specifically to frame the nature of those facets of the employer's operation that would potentially attract liability under both Section 20, but also Section 19. If all acts or omissions qualified, the use of the word practice would be odious, because if a one-off act was done once and not again, it would be difficult to see how it could be done in practice. The need for repetition, or the prospect of repetition, is necessary so the comparative exercise under Section 20, or as the case may be, Section 19, could be carried out. So as such, practice connotes some sort of continuum in the sense that it is the way in which things generally are or will be done. That does not mean that it is necessary for the PCP or practice to have been applied to anyone else. In fact, something may be a practice or done in practice, but carries with it an indication that it will or would be done again in the future if a hypothetical similar case arose. So the case of Starmer could be reconciled on the basis that the decision as to the part-time working in the context of that case was one that would be applied in the future to similarly situated employees. Similarly, Nottingham City Council and Harvey was explicable on the basis that the flawed application of a disciplinary process by a particular manager was not likely to be repeated in other cases, so the appeal was dismissed. The takeaway from this case is on the slide, essentially, that practice should be given its ordinary meaning, connotes some sort of continuum in the sense that it is the way things generally are or will be done. A practice arises, I apologize for the type of meeting, should be meaning. A practice arises but carries with it an indication that it will or would be done again in the future in a hypothetical similar case. So those are my first three. I'll hand you over to Geraint for a bit, and then we'll come back to me for a minute. Thank you.
Okay, thank you, Julian. If you can give me a thumbs up to let me know that you can hear me as well, please. Thank you. Well, just to reiterate, if you're a little bit late in joining us, we have the chat function that you can post any questions, and we'll be happy to pick those up towards the end. Also, just a reminder to keep your microphone on mute, please, and to not take control of the slides, as tempting as that might be. So the cases that I'm going to look at start with the case of Hill and Lloyd's Bank. This is a reasonable adjustments claim, and there are some similar themes to the Ashola case that Julian just took us through. But I'm not going to go in very much detail to go over again what Julian's been discussing, but touch upon a different element in Hill and also in Williams as well to follow. A bit of background in relation to the Hill case, first of all. This was a claimant that was disabled because she suffered from depression, which she said resulted from bullying and harassment in the workplace by two colleagues who were anonymized in the judgment, but I'll call them X and Y. She went off on long-term sick. She stayed employed. She'd been employed for 30 years. And on her return to work, the employer agreeing that she was a disabled person at that time, she said, look, the adjustment that I need is for you to give me an undertaking that I won't have to work with my colleagues X and Y again. And the employer said, well, we will do all that we can to stop that happening, but we can't go that far to make that undertaking. The employee turned around and said, well, okay, but if you can't give me that sort of concrete undertaking that this isn't going to happen again, it's only going to cause me more anxiety of the fear that I'm going to bump into these colleagues again in a work capacity down the line, and therefore it sounds to me like you might be making me redundant. Again, the employers disagreed with that, and the employee issued a claim for reasonable adjustments. Now, the EAT findings are interesting on this point for a number of reasons. First of all, there was an issue about whether or not the PCP in question was truly a practice, and Julian has touched on this already in the Ashola case and looking at the Harvey line of authority. Is a practice something that needs to be repeated? What about a one-off situation? Well, I'm not going to go into that in a huge amount of detail in this case. I'm going to touch on it more in Williams, which is the next case to come. But the PCP in Hill was found to be the practice of not giving undertakings, but rather giving words of assurance, if there can be a distinction, if I can try to illustrate that. The undertaking on the one hand being a essentially an obligation on the part of the employer that the employee wasn't going to work alongside X and Y again. Words of reassurance, the claimant said, were not sufficient to alleviate the anxiety that she felt that it could crop up again in the future. And that was the key substantial disadvantage, because as a disabled person, she was more likely to experience the anxiety of the unknown situation, whereas she said the undertaking would alleviate the unknownness and therefore was reasonable. And the Employment Tribunal agreed with her on all of those points. They agreed that it was the PCP was repeatable, more than just a one-off decision. They agreed on the substantial disadvantage that particularly affected her, and they agreed that in the circumstances of the employer, it would have been reasonable for them to go as far as making an undertaking. The ET also went further than that and said in the event that it's unfeasible for the employer to make that sort of undertaking or to guarantee that position, then they actually need to consider making the claimant redundant and therefore entitling her to a financial payoff. Now, the employer requested a reconsideration of that recommendation. And importantly, this was a recommendation by the tribunal to do positive things. We don't always see recommendations in practice in the tribunal. We're much more likely, I think, as practitioners to see financial compensation being the high point of an employment tribunal case. We do see reinstatement, rarely as well, but a recommendation under the Equality Act going certainly to this extent, I think, is quite rare. However, the reconsideration of the recommendation hearing, and that's not easy to say at 8:30 in the morning, the ET backtracked and they said, okay, maybe we went too far in the undertaking element. Maybe that was a bit vague. And certainly within the wording of the original recommendation, there were problems with it. Let me read you out what it said. So the tribunal makes the following recommendation. The respondent undertakes to ensure that the claimant does not work or interact in any capacity with Mr. X and Mrs. Y, and that in the event that this is not possible, that the respondent and the claimant explore suitable alternative employment within the respondent, and if this fails, the respondent uses its best endeavours to ensure that the claimant can leave the respondent with a severance package equivalent to redundancy payment applicable at the time of her departure. The Employment Tribunal backtracked on that, accepting that it was probably worded in a far too vague way. They were also concerned about imposing financial requirements on an employer by the way of a recommendation. The claimant appealed the recommendation reconsideration decision to the EAT. The employer appealed the liability findings as well. In terms of the liability findings, the EAT found no error with the tribunal's original view. They said that the practice decision was sound. The PCP necessarily had the substantial disadvantage, and that given the size and the administrative resources of the employer, the adjustment to give an undertaking was reasonable. There was nothing objectionable about an employer going to the extent of having to give an undertaking, even though the EAT did say that's probably going to be a rare situation. But looking at the recommendations element, this sort of cut a little bit both ways. The EAT accepted that the original wording, which I've just read out, was problematic. And they dealt with it in a very brief way, if you read the judgment, that it was too vague. There were issues about the time limitations on the recommendation, etc. But they did make a couple of really key points that we can take home about what might be appropriate recommendations. First of all, there is no reason in principle why recommendations should not necessarily flow from the reasonable adjustment that has been upheld as being sensible and appropriate in the circumstances. It makes sense, doesn't it, that if a reasonable adjustment claim is upheld, i.e. a failure to make a reasonable adjustment, then one of the remedies to that situation is to put that very adjustment in place. That makes sense. The second point to take from that is that that's going to be the case even if the period of time in question might well be indefinite. Now, the EAT made the point that there is a difference between an unknown time period and something being coined as indefinite, even though you might say to me, well, hang on, what's the difference there? But what they're saying is, from parties' point of view, if they don't know how long a recommendation is due to last for, that's one thing, that is vague. But if both parties know that this recommendation will last for the period of time that the employee is either employed or Mr. X and Mrs. Y are employed, even though nobody knows precisely what period of time that will be, they will know that will be the situation as long as those circumstances continue. So there is a difference, and there's nothing objectionable about having an indefinite recommendation. And in fact, anything less than that wouldn't have satisfied the needs of the claimant in the situation anyway, because of the anxiety of the unknown. What would have happened after 6 months or a year, say, if that had been the time limit on the recommendation? It wouldn't have actually solved the problem. And the second point to take home is that the EAT, confirmed there is nothing objectionable either about there being financial implications that flow from a recommendation. The whole point of a reasonable adjustments claim is for positive action towards a disabled person to alleviate the disadvantage. And guess what? Sometimes that means an employer having to pay out in order to facilitate that. There is nothing objectionable about that at all as a matter of principle. And the point about things being not feasible, again, that wasn't going too far. If it wasn't feasible for the employer to put the various steps in place to alleviate the disadvantage, then again, it was not objectionable for a recommendation to say a severance package should therefore flow. There's a logic between the adjustment that was required, which was upheld as to being able to alleviate the disadvantage. And if that adjustment was not feasible, then essentially compensation should flow, but in the eventuality that it was shown that that would not be feasible. And that's obviously a different situation to if the claimant had resigned, say, because of the failure to make reasonable adjustments, because the most that she would be entitled to then would be essentially compensation for the loss of employment in that situation. So an interesting case on recommendations. We don't see them a huge amount at appeal level. And it seems that there is a broad scope for tribunals based on the facts that they find and how they apply, particularly to reasonable adjustment claims, to go high and to go wide in terms of what they recommend. So an interesting case there to look at. Now, turning to the Williams case next, this is about a school teacher who worked in a primary school who was accused of a child protection breach and then also subsequent data protection breaches. There is also, within this case, if you go away and read the judgment, a constructive dismissal element to this, which I won't touch upon, but it is quite interesting to have a look at how that applies to the last straw doctrine, particularly when the final act in the chain is described as being innocuous. So that's an interesting point for maybe another talk at another time. But focusing on the discrimination element, a bit of background first of all. The claimant was a teacher and was disabled with a mental impairment of depression and anxiety, and this affected his response to stressful situations. All of that was agreed. He was suspended in April 2015 because of the allegations. He wasn't told any details about them. The process went on for a good while. His suspension was lifted. He wasn't given any teaching roles, but he was asked at one point to organise a sports day, which caused him significant stress, and he went off on sick again. By around October 2015, he was told the nature of the allegations was that he'd manhandled a child, but critically to the claimant, he wasn't told the name of the child or the name of the accuser involved. And he said that caused him more stress and more anxiety because it felt like he was only getting half of the picture against him in very serious circumstances for him. He submitted a series of grievances. Those were investigated. The disciplinary process was put on ice to deal with those. By July 2016, the disciplinary still hadn't been dealt with, and the claimant complained about the delay. By this point, he'd also been re-suspended because of the data protection issues that had arisen. Those data protection issues, I'm not going to go into a great deal, but essentially it was the usual thing of him emailing to himself and to a union representative certain documents belonging to the school, which he thought would be relevant to his case. So again, a situation that I'm sure we've all come across before. And he resigned in July 2016. Not going to go into the constructive dismissal element today, but the essence of his reasonable adjustments claim was actually quite focused. It was that the alleged PCP was that the claimant was not provided with the names of the alleged child and or accuser. But the question, of course, as I'm sure you can appreciate, is was this a flawed investigation or disciplinary process? And our sort of red lights are starting to flash Harvey at us, Nottingham and Harvey. Or could it be described as a practice that would therefore fit into Section 20, subsection 3 of the Equality Act and being a PCP? Now, at first instance, the tribunal made these findings. They found that after the conclusion of the internal investigation, there wasn't actually a specific reason why the name of the child and or the accuser couldn't and wasn't provided to the claimant. There wasn't a specific protection of the child reason. More, what the actual reason was, according to the tribunal's findings, was that the head teacher did it as a way of keeping control over the process. But the crucial finding of the tribunal on the back of that was that it could not conclude that this was an approach that the head teacher would have taken in all of the processes of that nature. Now, I wonder if there are any alarm bells ringing for you when you hear that word all. But on the one hand, we can understand the tribunal's thinking there. A practice can't be a one-off thing. It needs to have an element of repeatability about it. And this is a disciplinary process and an investigation process. If the criticism is of a failure within that process, is it stretching it too far to say that that's a potential practice rather than just a one-off event? Well, this is what the EAT said. It agreed with the consistent line of authority that we have now that there must be an element of repetition about a PCP for it to be properly understood as a practice rather than a one-off occurrence. However, that persistence or that repetition may be found, and this is an interesting phrase, within the four walls of how the employer is found to have treated the individual complaint. So I think what the EAT is saying is you don't need outside evidence of another situation within the same employer where another person was treated the same way, i.e. that the names and the names were withheld. You don't need that outside evidence. It can be within the four walls of the situation that's currently happening. I think that's a helpful illustration. But where does it actually take us? Now, the tribunal's key error here was actually quite a limited one, but it all comes down to that three-letter word, all. Their error was to set the bar too high. And they took the view at first instance that unless they could be convinced that this is how the head teacher would have dealt with all the similar circumstances, then necessarily the bar of achieving practice wasn't reached. And the EAT said, no, that's going too far. That is setting the bar too high. A general or habitual approach could suffice. So it's not fatal to a claimant alleging a PCP if there are other instances where different ways of dealing with it have been taken. And I suppose the upshot of that is, if that wasn't the case, an employer could attend an employment tribunal defending a reasonable adjustments claim in these circumstances and say, well, there's another teacher Mr. Jones, who was accused of another incident of child protection, and we provided him with the name, and therefore that shows that not in all circumstances we withhold the name, and therefore claim is defeated there and then. And so I think that it's right that that cannot be the case. The word all is too high, and the EAT accepted that there must be a degree of repeatability, but that doesn't have to be all the time. It can be general, it can be habitual, there can be differences in approach, but nevertheless, the four walls of the current circumstances may well show up that there is truly a practice as a question of fact. So an interesting case on reasonable adjustments there in Williams. And yeah, that key point about don't set the bar too high, tribunals, otherwise you're going to be in trouble with the EAT. I'm going to hand back to Julian now for the next case.
Thanks, Geraint. Next case now leads to another, I guess, age-old adage, which is never make assumptions. And that's exactly what happened in Rakova and London Northwest Healthcare NHS Trust. It's an important point to bear in mind. In this case, just to give you some background, the claimant was a nurse who suffered from disabilities that disadvantaged her with writing and reading and comprehension. She had difficulties completing her patient records and complained of having to stay late or take work with her. Various adjustments were made to try to resolve the difficulties, including the provision of assistive software and hardware. An assessment was carried out, and that recommended she should be provided with upgrades to the dictation software that she'd been provided with, but these upgrades sadly were not provided. So she brought a claim. She alleged a failure to make reasonable adjustments. She said she'd suffered a substantial disadvantage due to the application of the PCPs of having to use the conventional software provided by the trust, and that there were adjustments that could have been made, such as to the hardware, software, and access to the hospital Wi-Fi. The tribunal found that the provision of further equipment and software updates and better Wi-Fi access would have made the claimant more efficient. However, in the tribunal's view, and this is where the assumption comes in, a substantial disadvantage was not established by a desire to be more efficient, or that merely being able to show that Ms. Rakova could only work in a less efficient way was not sufficient to establish the substantial disadvantage. And so on that basis, it rejected her reasonable adjustments claim. As you probably gathered from the way I framed this, Ms. Rakova's appeal was successful for the EAT. The tribunal had erred in assuming that seeking to be more efficient did not amount to a substantial disadvantage. So obviously we need to understand that the substantial disadvantage is one that is a fairly low threshold in terms of establishing it. And that's exactly what was in the minds of the EAT in relation to looking at this particular point. They held the tribunal should have assessed the nature and extent of the substantial disadvantage in the usual way by considering whether Ms. Rakova's disabilities placed her at the substantial disadvantage in relation to the PCP in comparison to those who do not share her disability. So the conclusion and takeaway from this case is that it cannot be assumed that seeking an improvement in efficiency did not correlate with substantial disadvantage. It might have done. Without considering these matters, the tribunal cannot go on to consider, in the usual Environment Agency and Rowan sense, whether or not the duty to make reasonable adjustments had been complied with. And so the case is remitted back to the tribunal. And so with that short interlude, I hand you back to Geraint to take us through the end.
Thanks, Julian. Again, you can hear me, yes? Good, good. Well, I'm just looking at the time. We've got about 15 minutes probably left on the clock. And I'm going to ask for your patience with this next case of Morton and Eastleigh CAB, because this is perhaps one of the most boring judgments that you might ever take the time to read. So I'm going to do my best to avoid the need for you to ever have to read it yourself. And this is boring, not because of the people involved or because of the decisions involved, but because it's all about preliminary issues and arguments about case management, directions and orders. And there are a number of our esteemed Bristol region judges involved in this case. Although there's no criticism of them, of course, in my talk. This is about an issue of disability, usual stuff. Claimant alleges various number of disabilities, one of which was an eating disorder. But then there was a series of other disabilities that were linked to a depressive anxiety type disorder as well. At the start of the litigation, the respondent didn't accept any of the claimant's disabilities. And under the normal case management considerations, Judge Harper dealt with it at first. And he said, usual thing, exchange medical information, disability impact statement, and for the respondent then to indicate whether or not they concede disability, having received all of that. Now, there were some issues about the claimant providing that material, and the respondent did raise a number of complaints about that. But nevertheless, some material was provided, enough for, by the 19th of September, for the respondent to have accepted that the claimant was disabled in relation to one of her disabilities, the eating disorder, but they disputed the other disabilities. So technically, the claimant was a disabled person by that point in terms of the eyes of the litigation. However, from her case point of view, she also relied on the depressive and anxiety disorder type disabilities as well. Now, at the very first case management order by Judge Harper, he'd said in the event that the respondent does not concede that the claimant was a disabled person, a joint medical expert then would be put in train for the parties to deal with the issue of disability. But of course, by the 19th of September, a subtle change had happened, whereby the respondent accepted that the claimant was a disabled person, but the claimant wasn't happy with the definition of her as a disabled person, because she was saying, well, that's only one of my 4 disabilities. So I continue to need to argue that I am disabled in relation to the other points. Judge Reed then looked at the case and said, well, in my view, existing medical evidence only is likely to be able to deal with this. We've got the medical records by now. We've got the disability impact statement. The respondent has said, has laid out in clear grounds the reasons for their objections, plus they have also accepted one of the disabilities in question. So a pragmatic view taken by Judge Reed. But the claimant wrote to the tribunal and said, well, that doesn't satisfy me. And Judge Harper had said previously that I was essentially entitled to a joint medical expert report. It went back to Judge Harper, who wrote and said, in the event the claimant continues to rely on the 3 not accepted disabilities, a joint expert may be appropriate. That was at the beginning of October, and the tribunal wrote to the claimant and the respondent saying that there was going to be a preliminary hearing on the 30th of October to determine the issue of disability. At that point, the claimant was panicking and was saying, that's not enough time for me to get the medical expert. And by the way, we haven't agreed joint instruction, and we're confused about the situation because we have conflicting positions from 2 different judges that have been dealing with the case at case management level. So the claimant wrote to the regional employment judge, Pirani, and asked for an adjournment of the 30th of October hearing, saying it was too soon and she needed time for various things. To be fair, the claimant did not specify as clearly as she was later to do at the appeal that the main reason for the adjournment was for her to get the expert medical advice. It was a number of different reasons for requesting an adjournment. Judge Pirani refused that adjournment, saying that it wasn't necessary. That was on the 27th of October. And on the 30th of October, the parties converged at Southampton for Judge Kalanko, where the claimant made the same application again, basically before him, and said, I need an adjournment for a number of different reasons, including time to go and get an expert report. And Judge Kalanko followed the judgment of Judge Pirani and said, no, sorry, refused the adjournment application. The claimant then went to the EAT and was granted permission to appeal that following a Burns-Barker procedure, and the EAT nevertheless refused her appeal against the case management decisions, essentially to refuse the adjournment, and it went all the way up to the Court of Appeal. And having gone through the drama of the procedural process, there are a couple of take-home points we can take from this, which is why it features in our breakfast bites of cases that you should be aware of. And perhaps the most important point from a procedural level is this. by the time that it got to the Court of Appeal, no, actually, I should say that at the EAT and the Court of Appeal, but the Court of Appeal pointed it out in very clear terms, the claimant had appealed against Judge Kalanko's refusal of the adjournment request. She had not appealed against the earlier decision of Judge Pirani or the earlier indications from Judge Reed that the case could proceed with the existing medical evidence only. That was a fatal flaw in the integrity of her appeal. And at the Court of Appeal, it laid out very clearly that that is an inappropriate way of dealing with trying to challenge case management orders. If you're going to appeal a case management order, it needs to be the one of substance at the beginning of the chain. And in this case, it would have been Judge Pirani's, because he dealt with specifically the adjournment request at the first time, and that it was inappropriate to go to another judge at the same level of the hierarchy and ask for him to essentially give another decision on the same basis that the previous decision had been refused. That was inappropriate. So a fatal flaw in the appeal anyway. But nevertheless, there is another take-home point, which really shows the difference in approach between judges to the issue of expert medical evidence. There are some judges that will include it in a general case management order as almost standard rote. And there are other judges that take a more pragmatic approach and say, well, look, the tribunal has the experience and has the material in front of them to be able to make a determination on disability. We don't need a joint medical expert. So there is no right to having a medical expert at all. It's all going to come down to case management discretion of the tribunal. And as we know, that discretion is very wide. The EAT and the Court of Appeal confirmed what we all know, which is that the EAT is vastly experienced in dealing with issues of disability and won't be told whether a claimant is disabled or not simply because an expert says so. And similarly, when it comes to challenging case management directions, an appeal court is always going to find that difficult, because the tribunal is going to be in the position when making those case management directions and orders to balance the prejudice to both parties at the time. And they are at the coalface. They will see and appreciate the prejudice that any direction that they make is going to cause. And there's always a balance there. So some take-home points for us there, but perhaps the one that I'd reiterate again is, if you are going to go to the EAT, make sure you appeal right decision. And that takes us on, having got through that case, to the case of Gould and St. John's. Now, this is interesting on a number of levels, not least because of the gory details within the judgment of a pretty horrific marriage breakdown, which may or may not be your thing to read into. But it's a marriage discrimination case, and these are rare. It's also, of course, a direct discrimination claim, and that's important because marriage discrimination does not stand on its own little plinth. It all falls into the category of direct discrimination. We've touched a little bit upon that already this morning, about the thought processes that need to be involved. And I'm sure as well we're all aware of the various reams of case law on causation, if causation is truly the correct word to use, because in itself it's a slippery phrase. But some background here. The claimant was a church minister for a conservative evangelical church, and his marriage was breaking down for a number of years until eventually the claimant and his wife did separate. Sometime later, he was dismissed, and he claimed unfair dismissal and also direct discrimination on the grounds of marriage. And the interesting point about this case, from my point of view, is the difference between the reason for a decision in a discrimination context and context, and how we go about making the distinction between what is background context on the one hand and what actually was formative material that influenced the decision. In other words, what was the reason? Because, of course, under direct discrimination, as opposed to an unfair dismissal case, for example, say an automatic unfair dismissal in whistleblowing, the the sole reason, or the primary reason, as it would be in a whistleblowing dismissal case, is not the same situation in a discriminatory dismissal case and the direct discrimination. It's about whether or not there was a material influence. And that's a very different position to be in. And there is no necessarily quota to how much materially the decision needed to have been influenced for it to fall into the direct discrimination category. So it's a very tricky issue, and it's very fact specific as well. And the ET's findings of fact were always going to be critical, I think, in a case like this. But their findings were that on the evidence, the reason for the dismissal was a loss of trust and confidence by the leadership team that ran the church in their minister. And although the breakdown of the marriage had contributed to the loss of trust and confidence, it was part of the background or context rather than the part of the reason for the dismissal. Now, again, thinking about this critically, alarm bells could be ringing there. How do you distinguish between context and reason, especially when you accept that part of the trust and confidence being broken was the fact of the broken marriage? Add into that the particular context of this case, where you have a conservative evangelical church, some of whose members would have had the theological view that if a minister's marriage breaks down, that therefore that equates to a broken ministry. That was actually the pithy way that the claimant put it in his claim. Broken marriage equals broken ministry. And that it would include, potentially on a theological level, separation because of people falling out of love. We're not talking necessarily about adultery or abandonment here as a reason for the breakdown in marriage. Anyway, the ET made findings that certain members within the leadership team held that conservative view based on passages from Paul's writing in 1 Timothy and in Titus, and then also the Apostle Peter as well. In fact, the claimant, who was from the same cloth, shared that view as well. So there's this interesting religion and belief aspect to this case as well. But critically, the tribunal's findings were that it was essentially the aftermath of the breakdown of the marriage. It was the fallout within people within the congregation. It was some of the behaviors of the claimant, for example, to refuse to take a sabbatical, to refuse certain help that the church were willing to put into place, like counselling, and a number of different financial irregularities that were uncovered as well, that ultimately led to there being a breach of trust and confidence. And when you read the Employment Tribunal's decision as relayed in the EAT decision, there is this very fine line between, on the one hand, a belief that a broken marriage is indicative of the broken ministry, but on the other hand, things just going wrong, relationships breaking down within the church, there being pressure within the church, and ultimately disconnect between the minister and the leadership team, which were meant to be working in partnership to essentially run the church. Now, the EAT's view on all of this was that there is a correct distinction in this case on the facts, according to the tribunal's findings, between context and a material factor for the reason. And the EAT goes through helpfully the case law on this. It looks at the case of Ahmed, where even though the views of the Labour candidate in that case were relevant to the decision, there was a disconnect between that and his conduct. They also, interestingly, imported some of the religion and belief direct discrimination cases like Liddell, where the question was whether or not, because of the conduct or the manifestation of the belief, the claimant in that case would have been treated the same way as a non-religious comparator, and how that essentially is quite a high threshold, because if you can point to conduct or actions or manifestation of belief, then that creates a disconnect between taking the action because of the person's religion or belief. Although I accept that is, again, a difficult balancing act and will be very fact sensitive. So the EAT confirmed that it's appropriate in some cases to distinguish between context and reason. It's heavily fact sensitive. And also they quoted Paniato, which is a judgment of Mr. Justice Lewis from 2014 and Chief Constable of Hampshire Police, where said that there is no additional requirement in a case where there's a distinction to be met between context and reason. And that isn't necessarily going to be a rare case. In every case, it's going to come down to the mindset and the outworkings of the decision maker, and that needs to be looked into in a lot of detail. So fundamentally, the claimant's EAT decision went against him by way of appeal, but the EAT made this important comment, which is that if it had been the case that the decision had been made to dismiss him because of, and that decision had been significantly influenced by a belief that a minister cannot continue to serve if their marriage breaks down, then that may well be good grounds for a finding of direct discrimination. So on the facts of the tribunal, them erring on the side of it was the conduct, it was the actions of the claimant and everything else that was going wrong, which caused the breakdown in trust. If that had not strictly been the case, and more the conservative view of marriage and ministry, if that had been more of an influence on the mind of the decision, then absolutely a direct discrimination claim on the grounds of marriage may well have succeeded, but not on the facts of this case. So as a matter of law, the facts did not support a marriage discrimination finding. So an interesting one to go in to have a read if you can bear the grisly details. I'll hand back to Julian now, maybe to tie up.
Well, thank you all very much for being with us this morning. It may not have the comfort and the deliciousness of the usual breakfast bites that we would ordinarily put on in happier times, but we hope that you've enjoyed the quick run through of the 8 cases that we've looked at. We're now available if you'd like to ask any questions arising out of those cases or more generally within reason. So thank you very much on behalf of myself and Geraint and the Employment Discrimination team at Guildhall Chambers, and we hope you have a lovely day.